Good morning and welcome to Xenia Municipal Court. My name is Michael K. Murray and I am the judge here. You are here this morning for your initial appearance. Most of you are here for a traffic offense, but a few of you may be here upon a criminal complaint. When I call your name, I'll ask you to step up to the lectern. I'll make sure you understand the charge you are facing, and at that time you will be called upon to enter one of three pleas. You can plead guilty, not guilty, or no contest. If you plead guilty, that is a complete admission of the offense. If you plead not guilty, obviously, that is a denial of the offense. Let me explain the legal effect of pleading no contest. If you plead no contest, while you are not admitting wrongdoing, you are admitting the facts set forth in the citation, complaint, and report. I will review them. If they state the elements of the offense, I will make a finding of guilt. However, your no contest plea cannot be used against you in any future criminal or traffic or civil proceedings. Let me give you an example of when you might want to consider pleading no contest. Let's say you are here today charged with failure to control, failure to maintain assured clear distance ahead, failure to yield, something where there is an accident involved. You may want to get rid of your case today, but there's the possibility somebody could sue you down the road for personal injury or property damage. If you plead no contest and I find you guilty, since you have not admitted wrongdoing, your no contest plea cannot be used against you in that future lawsuit. If you plead guilty today and somebody sues you down the road, since pleading guilty is a complete admission of the offense, that could be used against you. But again, if you plead no contest, your no contest plea here today cannot be used against you in any future criminal or civil litigation. So if you want to get rid of your case today, but there's the possibility that someone could sue you down the road, you might want to consider pleading no contest. If you plead guilty, or if I find you guilty after a no contest plea, I will give you an opportunity to make a statement. After you make your statement, I will impose what I believe is the appropriate penalty. If I impose a fine and court cost today, you must be prepared to pay that in full. So that you do not get sticker shock when you go to the clerk's office, I want to advise you that our basic court cost here are $110. Of that $110, approximately half we are required to send to the state, and about half stays here locally. I tell you this because in a lot of basic traffic offenses, my typical penalty might be something like a $50 fine plus court cost. That's actually $50 plus $110 court cost for a total of $160. I also want to advise you that if you do not pay your fines and court costs in full today, we may turn your case over to a collection agency. I want to advise you that under Ohio law, any company that does collection work for a court is allowed to add 30% on top of your fines and court costs. For example, if your fine and court costs came to $200, if you do not pay that today, and we turn it over to a collection agency, the collection agency can add 30% on top of your $200 fine and court cost. In that situation, $200 immediately becomes $260 when the 30% is added on top of it. Additionally, we could send your unpaid fines and court costs to the Ohio Attorney General's office, who is allowed by law to use all legal collection manners that the Ohio Attorney General's office has at its disposal. I tell you this because I want you to understand that if you do not pay your fines and court costs, and if it gets turned over to collection, the money due can increase pretty quickly. So it's definitely in your best financial interest, if at all possible, to take care of your fines and court costs today. If you plead not guilty, you will go to the clerk's office to get a trial date. When you first go to the clerk's office, the clerk will ask you if you want to sign a time waiver. Let me explain the legal effect of signing a time waiver. Depending upon the charge you are facing today, By law, we are required to bring your case to trial within 30, 45, or 90 days. If you sign a time waiver, all you are saying is that we can set your case farther out than 30, 45, or 90 days. You are giving up your right to a speedy trial. You are not giving up any other rights that you have. You are just saying that it's okay with you if we set your case for trial farther out than 30, 45, or 90 days, whichever of those time limits is applicable to your case. You may want additional time to consult an attorney. You may want additional time to locate witnesses. You may just want some extra time to prepare for your case. Please keep in mind, though, that if you want your case tried within the time set by law, just respectfully tell the clerks that you do not want to sign a time waiver, and we will set your case for trial within the time required by law. If you are here today on a traffic citation, you must show that you had insurance on the date you got your ticket. If you showed proof of insurance to the officer when you got your ticket, it will be marked on the ticket. I'll make reference to it, and that's the end of the matter. If you did not have insurance with you when you got your ticket, but you have it today, please have your proof of insurance out and be prepared to show it to the bailiff. If you did not have proof of insurance with you when you got your ticket and you don't have it with you today, perhaps it's out in your car, perhaps it's on the kitchen table, maybe you just can't find it. The key is you must show us proof of insurance before next Tuesday at noon. Some people, when they go out to the clerk's office, ask for our fax number, and they have the insurance company fax proof of insurance to us. We don't care how you get the proof of insurance here. Just remember, you must show proof of insurance before next Tuesday at noon. Every Tuesday at noon, electronically, we send to the Bureau of Motor Vehicles the names of everyone who has not shown proof of insurance. If you do not show proof of insurance when you got your ticket, you will lose your license for a minimum of 90 days, longer if you've had prior offenses where you did not show proof of insurance. If you were driving someone else's car when you got your citation, you must show that vehicle had insurance on it when you got your ticket. Either you or the car's owner must show proof of insurance before next Tuesday at noon. If neither you nor the car's owner shows proof of insurance before next Tuesday at noon, both of you will lose your licenses, again for a minimum of 90 days, perhaps longer, if you do not show proof of insurance on the vehicle on the day you got your ticket. I also want to advise you that if you are here today on a traffic citation involving speeding, if I find that your speeding is reckless, in other words, driving without due regard for safety, I could suspend your driver's license up to a maximum of 1 year. If you are here today on a charge that carries possible jail time, I will make sure that you are aware of that. If you are facing possible jail time, you have a right to an attorney. If you cannot afford an attorney, we will refer you to the public defender's office to see if you qualify for a court-appointed attorney at no cost. We will give you a piece of paper that has the address and the public defender's phone number on it. The paper will also require that you come back to court 1 week from today at 11 a.m. for an attorney status hearing. If you contact the public defender and the public defender accepts your case, or if you retain your own attorney, you hire your own lawyer, and we have proof of that before 1 week from today, then it will not be necessary for you to return to court in 1 week for that attorney status hearing. However, if you do not contact the public defender, or if you do not qualify for a court-appointed attorney, and if you have not retained your own attorney, then it will be necessary for you to return to court 1 week from today for the attorney status hearing so that we can make sure you have an attorney to represent you on your case. At this point, I want to address my next comments to those of you who are here today facing the charge of driving under suspension. If you are here today charged with driving under suspension, you should have received a packet of information when you came into court about a program here we call the Deema Plan. DEAM stands for Driving Under Suspension Earned Amended Charge. It's a program where individuals who have been charged with driving under suspension can earn the opportunity to have your charge amended to no operator's license if you are valid by the time you come back to court and are prepared to pay a fine and court costs. If you did not receive that packet of information, please notify a bailiff immediately at the end of these opening comments. If you received the packet, please review the information carefully. I will talk more with you about this plan when I call your case. When you come up to the lectern, if you have any questions about your rights or the court process, please ask. I do not want anyone entering any plea today or taking any action on your case unless you are absolutely certain of your rights and the court process. This may not be the appropriate time to have a 20-minute discussion about the facts of your case. However, I do want to make sure that all of your questions about the court process and your rights are answered before you make any decisions and take any sort of action. I also want to advise you that every Wednesday and Friday morning we have open arraignments like this. Every Wednesday and Friday morning there are many people in court. I can tell you from past experience that it's probably going to take 1 to 2 hours to get through this many cases. The reality is somebody's going to go first and somebody's going to go last. And it's not necessarily related to the order in which you signed in. I am asking you to be patient. We're going to try to move through the cases as quickly as we can, but when you're up here on your case, we want to give it the time and attention that it deserves. This matter is important to you, and it's important to me as the judge of this court. I also want to give you a warning required by law. If you are not a citizen of the United States, you are hereby advised that conviction of the offense to which you are pleading guilty or no contest may have the consequences of deportation, exclusion from admission to the United States, or denial of naturalization pursuant to the laws of the United States. I want to advise you that these proceedings this morning may need to be interrupted for a few moments as we deal with people who are actually in jail. We have to match our work here with whenever the jail is available to put some individuals on the TV monitors to take care of their cases while they are actually still in jail. One final matter. When you go to the clerk's office, please remember that the clerk did not write you the ticket and did not impose the sentence. The clerk is doing his or her job of processing the documentation on your case. Please treat them respectfully. We will be starting soon.